This is 10 legal tips for starting a new studio, and the organizers requested that we add you won't believe number 11, so that it was even more clickbaity. So as a little bit of background, I'm Brandon Huffman. I am an attorney in Raleigh, North Carolina. I have my own law firm called Odin Law and Media. Until recently, I was at a firm with about 30 people specializing in tech and life science startups. I spun out to focus on digital and interactive media and games companies. I'm also the general counsel for the International Game Developers Association. I talk about games anywhere anyone will let me if it's a legal event, and I talk about the law anywhere anyone will let me if it's a games event. So with that said, the first tip is business, which is not really a tip. So each one of these orbs is a tip, but that's where our 10 come from. But each one of these we're going to dive into a little bit. So the basics of business law. So what I'm going to do is I'm going to go through basically your first, second, and third year of law school in about an hour. So I'm going to go through things very, very quickly. If you have questions, feel free to shout them out. If I'm going to answer them later, that's all I'm going to say, is that I'll answer it later. So business and corporate law basics. So what is an entity? So an entity is a business entity. It is a separate being, corporate personhood, from you as a person. Why is that a thing, and why is that important? So the reason that that's a thing and the reason it's important are liabilities. Having a business entity that is separate and apart from yourself enables you to take on risks that you would not personally take on. So if you want to take out a loan in the name of a business, you can do that. If you want to buy property in the name of a business, you can do that. If you want to sell a game to the marketplace in the name of a business, you can do that. And then most of the risks of that endeavor are pushed off onto the business, provided we do it right. So the first thing about businesses that we'll talk about is formation. So when you form a business, there are a lot of different forms that it can take. It can be a sole proprietorship. A sole proprietorship would be if you yourself went to your garage and started making widgets and selling them on the internet. You did nothing else, that's all you did, you're a sole proprietor. The downside of that is there's no liability shield the way I just talked about that. The upside is that it's very simple to do. You may have to deal with a homeowners association or something like that, but other than that, very, very simple. The next form it can take is a partnership. A partnership is that exact same scenario, but it's you and one other person. A lot of people think to form a partnership, you have to have signed something. A partnership is formed the instant two people engage in business together in a joint venture. Whether or not you ever sign anything, you have a de facto partnership. If you're in a band and you haven't signed a band agreement, you're in a partnership. And there's actually case law in most states that supports that, specifically about bands. The upside to a partnership, again, is that it's very simple to form. You just do it. If you want to formalize it, you can, and as an attorney, we always recommend that you do, because otherwise the assumption is everyone has equal control, everyone has equal liability, which might not be the way you actually want to do it. The other benefit is that it is a single tax, and I'll talk a little bit more about taxes in a little bit, but some types of businesses are taxed at the business level, as well as your individual income is taxed from that business. The admin is trickier if you decide to formalize it. There is something called an LP structure, which would be a limited partnership. Probably none of you will ever involve yourself in a limited partnership unless you make so much money off your games that you want to start a venture capital firm or something like that. An LP system is where one partner takes on all the liability, or a set of partners, the general partners, take on all the liability, and the LPs basically put in their money and let that go to risk, but don't risk anything else. An LLC can be single or multiple owners. It is tax flexible, meaning you can do taxes a lot of different ways, which we'll talk about in a bit. You do get the liability protection that we talked about that. The administration of an LLC is a little bit more complex than a sole proprietorship or a partnership. There's a filing that's required at your state Secretary of State's office. There's going to be an annual reporting requirement, and you do have to observe some corporate formalities. So, for example, you have to have a separate bank account. That's the cleanest way to say it. What you actually have to do is not commingle your funds with the business's funds. The easiest way to do that is to have a separate bank account and make sure the business funds stay with the business until you decide to pay yourself, which you can do. But if you commingle funds, you lose the liability shield. The same if you don't observe other corporate formalities, like most states require an LLC to have an annual meeting of the members. If it's just you, you put a note on a piece of paper that says, I had a meeting today, and you fulfilled that requirement. But you put it in a binder, you file it away, and you say you had a meeting. The next way you can form as a business entity is as a corporation. So a corporation is the most administratively complex of the ways we've talked about. It does have benefits to that complexity. So you can have a single member corporation, you can have multiple member corporations, you can have as many members as you want in a corporation. Shareholders, you can have as many shareholders as you want. Microsoft is a corporation. It's less tax flexible than an LLC, so you can only be taxed as for our purposes, you can only be taxed in two ways, either as a C Corp or an S Corp, which we'll talk about in a little bit. Corporations have the strongest liability shield. It's similar to an LLC. It's mostly the same as an LLC. It's a little bit better because typically a corporation is going to have a board, and the board is going to make the high-level decisions, which if you say you're on the board and you're also the CEO and you're also the biggest shareholder, a lot of decisions you make would be considered interested transactions, and if you can remove yourself from that decision and have the board make it, you've even further removed yourself from liability by pushing that off onto somebody else. Now, there are lots of ways to claw through that shield, so don't think that it's a foolproof system and it's impossible to get through that. And also, if you stack your board with your sister and your son and your dad, it's still an interested transaction. Again, this is all very high level, barely touching on a lot of this stuff to get through it all. The next thing I want to mention is local licenses. Depending on where you are, you may have to get a business license, which is a license from wherever your local government is that says, yeah, you can do business here. Depending on the type of business, you may need a privilege license, which would be another license, usually from a state or county government that is similar, that says, yeah, you can do your business here. You may need to pay for occupancy permits that basically say, yeah, you can do business in this building. All of these are ways that local and state and county governments make additional revenues, but you need to be aware of them because typically not doing them comes with penalties if they find out later. And with that, we've covered point number 1, business. So that was exciting. So we'll talk now about something that's probably a little bit more interesting to most of you, IP. So what is IP? IP is a term that a lot of lawyers hate because it means intellectual property, which doesn't really mean anything under the law. Intellectual property is made up of all of these things you see along the side. One of those is not an intellectual property right, but we'll get to that. So what it really means in common vernacular is your intangible assets, the value that you've built up in the brand of your business, the value you've built up in your characters and your games and everything else that you've built that isn't a physical asset. An inventory of games that you have sitting on a shelf is not IP. What makes up that inventory, when you pull it off the disc and you say, this is the ideas in here, that's your IP. Lawyers hate it because, again, it means nothing on its own. It means ideas, right? So then we get into what are different types of IP. The biggest type, in my mind, for most game developers is copyright. Copyright protects certain statutory exclusive rights in creative works that are fixed in a tangible medium. That's a fancy way of saying that it doesn't protect ideas, it protects the expression of that idea. So if I say, I have an idea for a game that has a plumber who's Italian, you can make a million different versions of that. But if you make Mario, you've copied someone else's game. So copyright, you get your copyright, you get rights in your creative work the instant you fix it. So if you're a songwriter and you write down the song, you instantly have a copyright protection in that. If you are a programmer and you type it into the computer and save it, or you write it down on paper, you instantly have copyright protection on what you've done. There is a registration system for copyrights. You can register them with the Copyright Office. Registration is a prerequisite for a lawsuit, so if somebody's infringing it, you do have to have it registered to sue them. It is not required for a base level protection. Basics of copyright infringement. So copyright infringement means doing one of the things with someone else's copyrighted work that is their exclusive right to do. So for example, in the game world, think about distribution. You, when you create a video game, have the exclusive right to distribute that video game until you sign a contract that says otherwise. If someone is distributing your video game without your permission, it's copyright infringement. The same is true if you want to create derivative works. So what does that mean? So if you create a video game and then somebody makes a film that is clearly based on your video game, that's copyright infringement. The same is true the opposite direction. If you are making a James Bond video game, you'd better have permission to do it because James Bond is a copyrighted work of someone else. There are ways that you can maybe argue that it is fair use to do some of those things. Don't do that. Fair use, I say that very deliberately, don't depend on fair use. Unless you have millions and millions of dollars to spend on lawyers and you're doing it out of principle, fair use is an affirmative defense, which means that you get sued, and to argue fair use, you're basically saying, you can argue in the alternative, but you're basically saying this is copyright infringement, but it's protected copyright infringement. It's a fair copyright infringement. It's one of a few certain defined categories. So, for example, it's a parody that comments on the original work. Making something and adding something, a layer on top of it, like making Mario and adding more mustaches, is not a parody. That's copyright infringement. Even if it were making Mario and making the whole game about Nintendo and how Nintendo has, I don't know, some unfair labor practice or something, that would still, even if that is a defensible parody, it's a fair use, but Nintendo can still sue you, and then you have to defend that your use was fair under the fair use laws. So you're going to be spending lots and lots of money to get out of that lawsuit. So it's safer just to create your own original works. Yeah?
When you get out of that lawsuit, can you get them to pay for it?
Probably not, but maybe. Mm-hmm.
Didn't they just rule, I think it's 2015, that if somebody comes after you for copyright infringement and it's spurious, that you could sue back?
Yeah, so that is true in the Ninth Circuit and a couple of other places. Yeah, and a couple of other places. But even then, you're going to be fronting those litigation costs. I don't think most lawyers would take a copyright infringement case on contingency. Especially the defense of a copyright infringement case, where the best case scenario is that you respond and win some attorney's fees. Yeah, most attorneys I don't think would touch that unless you were paying them hourly. The next big category is trademark. So what is trademark? Trademark is the area of law that protects names, logos, phrases, etc., that identify the source of goods or services. So I've got the example there. The name, logo, and phrase, Nike, the Nike swoosh, and the phrase, just do it, are all registered trademarks of the Nike Corporation or Nike Company or whatever their company is actually called. They're all registered trademarks of that company. You can also have a registered trademark in a sound. You can have a registered trademark in a very specific appearance. So if you have a building that always looks the same, you can get a trademark in that. Registration, I've said here, registration is critical here, and the reason I say that is that you do get trademark rights the instant that you use a mark in commerce. So if you put out a game, the game has a title, you have some trademark rights in that. Enforcing those rights is next to impossible because you're going to be doing it on a state level, because the rights you've gotten are common law rights. So there is no federal trademark right without registration, or no good federal trademark right without registration. What you get is your state common law trademarks. Most states have their own registration systems as well. Those, I think if you're going to spend the time and money to do it, just do the federal one and get the nationwide protection. The next thing we're going to talk about is patent. So patent, as compared to copyright. Copyright protects your creative expression when you fix it. Patent protects a certain amount of exclusive use of a useful article. So if you invent a new type of machine, that you're not going to copyright that, you're going to patent that. Patent is basically a slip from the government that says only you can use this and only you can do this for a certain amount of time, and the amount of time varies depending on the type of patent. So if you have a process, and this is where it usually comes up with software, if you have a process that touches on something outside the software and is a novel process that you think only you should get to use because you invented it, you may be able to get a patent on it. Software patents are very difficult to get. They're not impossible to get. They are very expensive to get a patent attorney and get a patent prosecuted is very expensive. The downside to getting a patent is that it does require disclosure of the idea. So when you file a patent application, you basically say to the government, this is the whole idea, this is why we think it's new and innovative, please let us protect it for the next 10, 7, whatever the number is, years. And the government either says yes or no. If they say no, you've just told the whole world the idea. Which brings us to the next topic, which is trade secrets. So a trade secret is essentially any idea that derives value from its being secret. So the Coca-Cola formula is the classic example of this. The Coca-Cola formula, they could have patented the Coca-Cola formula 100 years ago, and then everybody would know what it was, and when the patent ran out, everybody would have started making generic Coke, just like the pharmaceutical industry does. The pharmaceutical industry gets their patent protection because they know that researchers are working on the same thing in more than one place, and it's a race to see who can do it first and get the patent. And then they get exclusive right to do it for 10 years, and they shut their competitors out of the market. And as soon as that patent runs out, generic versions of those pharmaceuticals pop up. So trade secrets, basically, in order to preserve trade secret protection, you have to take steps to make sure that your idea stays a secret. And the simplest version of this is a non-disclosure agreement. If you have something that derives value from being secret, like a vendor list or a customer list or a certain business model that can't be protected through anything else, you can still contractually protect it. So anytime you disclose it to someone else, you say, you can't share this beyond what I've shared it with you to do. And that is the starting point for trade secret protection. So the last thing I've listed here under IP is not actually an IP right, it's a privacy right, and it's publicity rights. So who here heard about Lindsay Lohan suing over Grand Theft Auto? So there was a character in Grand Theft Auto that looked a lot like Lindsay Lohan, in fact looked almost exactly like one particular photo of Lindsay Lohan, and so she sued. That's what you're trying to avoid in these types of cases. So if you're making a character in a game, don't look at one real life person and copy their likeness into the game. That's a bad idea. Publicity rights, I said, are actually privacy rights. The privacy right, the basic premise here is I get to control the use of my image for commercial purposes. The amount to which I get to control it varies by state. Some states extend it beyond my death, so my children and grandchildren get to protect it. That's why you don't see, or that's why you do see very particularized licensed uses of certain celebrity likenesses who've been dead for years and years and years, because their families, once they were dead and gone, decided they still needed to make some money off of them. All right, so now we have IP and we have business. So I'm going to talk very briefly about something that's not really a legal issue, but does underlie a lot of the rest of what we're going to talk about, and that's risk. So risk is inherent in literally everything. No matter what you do, there's a chance you're going to get sued, there's a chance someone's going to steal from you, there's a chance you're going to trip and fall and get hit by a bus. So how do you avoid or mitigate risk is a lot of what we're going to talk about in a lot of these other things. The biggest thing we're going to talk about that underlies literally everything from here on is contracts. So what is a contract? A contract is essentially a tool for risk mitigation. It's a way for you to memorialize a deal between two people or two entities or a person and an entity that says, these are the terms we've all agreed to, and if one of us doesn't abide by this, they're in breach. So what does it take to form a contract? It takes an offer, it takes acceptance, and it takes consideration. That's it. So if I say to you, I will buy your car for $5, you say yes, and I hand you the $5. I've offered, you've accepted, I've performed, I've given you the $5. and you have to then perform and give me your car. It's that simple. Now, there are a lot of other things here. So is a writing required? Is a contract in writing? So certain types of contract have to be in writing. You can't sell your house without putting it in writing. That's the law in all 50 states. To sell real estate requires a contract in writing to do it. Federal law requires that a copyright transfer be in writing. That's important, and we'll come back to that in a little bit. So key terms, okay, so real quick, templates and forms. Can I just pull my contract off the internet? Well, I don't know. Sometimes, yeah, sure. If that contract that someone else drafted for some other situation happens to line up precisely with your situation, great, use that contract. But make sure you know that that's what it does. And that's the difficult part. If you're pulling, especially if you're pulling pieces and parts from contracts in various forms and things from all over the internet, you better know what those things say, because they might not say what you think they do, and the other party might read them and go, oh, this is a great term, I'm so happy, and they're signing it in reliance on that, and you don't even know what it says, and then 5 years down the line, something happens, and they point at the contract, and you go, well, that's not what I meant, I just pulled this off the internet, and they say, that doesn't matter. We agreed to this, and you drafted it, so it's going to be construed against you. But if it does line up perfectly, by all means, save the money, go for it, take the risk. It's all about risk mitigation, right? So key terms in most contracts, payment or other obligations, representations and warranties is basically one party saying to the other, I promise this to be true, and if it's not true, I'm in breach of the agreement. Conditions are things that basically say, if this doesn't happen, I don't have to perform. So if I don't get financing, I don't have to hire you. If my game never releases, you don't have to market it. Those kinds of conditions. Liability issues, this is where you see in every end user agreement you've ever read, we have no liability for X, Y, Z, et cetera. Liability can be transferred in an agreement. It's all about risk mitigation. In any sort of contract, you can push some risks onto the other party, and that's what liability issues do. That's why that's in there anyway. So you can see limitations of liability. You can see disclaimers. So we aren't liable for this, period. And you can see indemnification. So if this happens, you're going to cover us, and you're going to pay the legal fees, and you're going to pay the damages, even though maybe we're also involved. Remedies, so what happens if someone breaches the agreement? That may or may not be addressed in the agreement. If it's not, it's addressed by common law. And termination, so what happens at the end of the contract? How can you get out of it? That's an important thing to consider for almost every agreement. So what's the hybrid between risk and contracts? Insurance. So insurance comes in a lot of different forms. General liability, errors and omissions, cyber liability, auto, key man or life insurance. General liability protects trip and falls in your office. E&O protects if your directors vote the wrong way according to the shareholders and they sue the company. Cyber liability protects you if you have a hacking incident, or may. You should read that one carefully because those are all over the place. Auto insurance protects you if you have a truck that runs into someone. And keyman or life insurance should be called death insurance because that's what it's actually insuring for. If somebody dies, somebody else gets a payout. That's literally what it means. Keyman insurance sometimes is required by a publishing agreement. If you have a very particular talented member on your team, they may want you to get keyman insurance on that member so that if that member gets hit by a bus on their way to work, the company gets some money that they can then use to hire another talented person. So the hybrid between IP and contracts is a license. So a license is a contract that basically allows one party to use the IP rights of another party. So it has the same key terms as any other contract that we already talked about a little bit. The ones in particular that you should pay attention to in licenses, rights, territories, the term, exclusivity, and termination. So rights, what IP rights are actually transferring or being licensed, the territory, for what area are they being licensed, the term, for how long, exclusivity, is the license one where if they get the license, no one else can use it, or is it one where if they get the rights, you can still license it to other people? Alongside that, I did not include this here on this list, but sub-licensing. do they have the right to then also let other people use their license? So if you license your game to a distributor, can the distributor turn around and license it to other distributors? That kind of idea. Termination, again, is how you get out of the deal. With a license, I would also add what happens to the licenses that are already floating out there. So if you've licensed your game for physical production, for example, and you terminate the agreement, do they get to continue to sell what they've already manufactured? Do they get to continue to manufacture in the territory? Do you claw everything back? How does that all work? That's all important to consider. So the hybrid between business and contracts is basically money, right? It's everything that comes around the money side of the business. So business is money, and people with money write laws. And that's the simplest explanation here. So there are a couple of categories of things I'm going to talk about under this. So the first is capitalization. So what does that mean? It means who owns what part of the business and what did they contribute for it. Beyond that, you'd want to know, kind of as a subset of that, if the business makes money and wants to distribute it out to the people who own it or allocate it. So distributions. If the business wants to give money away, how is that handled? Typically, if you're in an LLC, that's going to be handled in the operating agreement. It's going to specify when and how that happens. If you're in a corporation, it's typically going to be handled in the bylaws, and then it's going to be voted on by the board of directors. They may never make any distributions. That may never happen. If you have investors, there may be required distributions. If you have an operating agreement in a state with a lot of tax, I would suggest having a tax distribution requirement so that members don't get taxed on things that they've never actually physically held the cash. Allocations are different. That's when money comes into the business, especially specifically in an LLC or a partnership. When money comes in, how is it allocated for tax purposes? Usually that's going to line up with the capitalization. It may not in certain specific circumstances. Preferences. If you sell the company, who gets paid first and what do they get paid? So if you have capital investors that put money in and they take 10% of your company, they're probably going to want to get paid before you get paid, right? Not always, a lot of the time. So if they put in money and they have, say they get a return on their investment, they put in $1 million for their 10%, and they have a 10% return, and you sell the company a year later. Well, you sell the company a year later for exactly the same price, $10 million. They're going to want $1.1 million before you get any. And so that means if you sell the company for $10 million and it's got $5 million in liabilities, you're going to pay those liabilities off first, then they're going to get their $1.1 million, then you're going to get your portion. That can be structured a million different ways. That's one example. But again, all of that is handled by contracts. So types of investment structures: equity is someone buys a chunk of your company. A note is debt. It means someone hands you money and you promise to repay them. Certain types of notes are what are called convertible notes, which means that they are debt that might convert to equity later. Usually, if you're going to do that, you do that in the early stages, and then if you're going to do another round of financing, that note might convert into the next round at some sort of discount to incentivize people. Again, a million different ways you can structure this, all dictated by contract. There are other investment structures. There are people who will invest on a profits interest basis. That's tricky to structure. Anyway, there are a million different ways to structure this. So then business and money and contracts and tax. So tax is something you should talk to your CPA about. I'm going to touch on it here, but know that you should talk to someone else about it. So tax is what you pay to the government for the money you make. That's the income tax. There are a lot of other taxes, but income tax. In a sole proprietor, a partnership, or most LLCs, you're going to be taxed as what's called a pass-through entity. So that means that you individually, the owners, pay taxes on the business's income. So that's post-deductibles, post-expenses income. You pay tax on that personally, whether or not the business pays that money out to you. If you reinvest it in the business, it's like you got taxed and then reinvested it. So you still have to pay that tax. That is beneficial for a lot of cases where the business makes money, but because the individual tax rate is lower than the corporate tax rate for you in a certain tax bracket, it makes sense to pay the individual tax rather than the business tax. A C Corp is going to be taxed at the corporate level when the corporation makes money. An S Corp is going to be a pass-through entity like a partnership or an LLC partnership. The limitations of an S Corp are that it can't have multiple classes of stock. It's limited on the number of investors it can have, and it's limited in how it can structure the corporation overall in a couple of other ways. But LLCs can elect to be taxed either as a partnership, a C Corp, or an S Corp, which is why before we said they have tax flexibility. They can decide how they want to be taxed. C Corps and S Corps are both just corporations that have made a similar election. At a certain point of income, especially if it's just you, it will make sense. If your plan is to stay one person forever, it will probably make sense to make an S Corp election. An S Corp is required to pay a service provider who is an owner a reasonable salary, which means you're going to be paying individual income tax, and the company is going to pay payroll tax, and then anything over any profits over and above that can be distributed as distributions, and then you'll pay tax as though it were a partnership after that. But there's some math to do there about what your individual tax rate is, what the corporate tax rate is, where this election makes sense and where it doesn't. So that's something to talk to a CPA about. I'm not a CPA. I'm not going to give you tax advice. So we've talked about this whole top half. So one thing that I mentioned, payroll tax, so we'll come down here to service providers. So this is the marriage of contracts and money, right? And we drop down here. Service providers are people that you are paying to do work for your business. If you're not paying them, you better have a pretty good reason why. If it's because they're being promised equity in the company, you better make sure you know how that's functioning. If you're doing something where you're saying, you get 7% of my company if you do this work, does that have vesting? Do they get that 7% the day they start doing the work, or do they get it and then they have to stay for 4 years in order to actually have the full beneficial ownership of it? In either of those situations, you need to consider the tax consequences. If you're handing them a bunch of equity up front, if I hand you money, you have to pay tax on it, and I have to pay payroll tax if it's for a service provider. If it's for an employee service provider, I have to pay payroll tax. If you do that with equity, the same is true. So if I hand someone 7% of a company that's worth $1 million, they've just made $70,000. There's tax consequences to that. You can't just give out equity and pretend it didn't happen. The IRS will come after you if they find out. They don't like that. They don't like to not get paid. So the employee versus contractor distinction is one that comes up a lot, especially in the games industry. The way it is supposed to work the way it has historically worked is there's an 11-factor test that says whether an employee, or whether a service provider is an employee or a contractor. Those 11 factors kind of go all over the map, but the general crux of them was who is controlling the work. Is the employer requiring you to be in the office from 9 to 5 every day? Does the employer provide all the equipment? Does the employer provide explicit instruction on how the work needs to be done? Or does the employer say, give me these 15 art assets, go have fun? Because those are two different relationships. And if it leans towards control, the old test would have said that that person is more likely an employee as opposed to a contractor. There are other factors that a lot of game developers lean on to try to push people into the contractor category, like, for example, if it's a discrete project and you know the person's only going to work for 3 months, that leans towards contractor. But if they're going to work full-time for 3 months and you're going to have all control over it and you might keep them on afterwards, maybe not a contractor. Unless the contract specifically says it expires after 3 months and we'll renegotiate at that point, something like that, then you may be able to swing that. The new test is actually less favorable to employees, and this was something that passed under the Department of Labor under Obama, so it may shift back, but the newer test leans more on the dependency of the worker. So if the worker works for you and only for you, and that's how they make all of their livelihood, they're more likely an employee. If they work for you and 15 other people and they make 1/15 of their income from all of them, they're much more likely an independent contractor. The consequences of misclassifying someone as a contractor. So the reason people like to push people into the contractor category, in most states, it's mostly just about taxes. In most places, it's because contractors pay their own taxes. You hand them a check for X dollars, they pay their income tax on those X dollars. In some states, it also has to do with the rights that employees have. So, for example, in California, employees have a lot more additional rights to meal and rest breaks, to certain benefits, to certain non-discrimination that contractors don't get, or don't get as strong a right to. The consequences of misclassifying someone who is supposed to be an employee as a contractor is basically twofold. First, you'll have to pay all of the back tax. If you get caught and if you get subject to enforcement, you'll have to pay all of the back taxes. So all of the payroll tax that should have been paid to the IRS for hiring that person will then be owed to the IRS. Also, the IRS doesn't like to not get paid, so there will be penalties. So you'll have to pay all of the back taxes and penalties. The other flip side of that is that if you have an independent contractor, you're not paying them overtime. You're not paying them overtime. You're not paying unemployment insurance on them, and the Department of Labor doesn't like that. The Department of Labor wants you to follow the labor rules for employees. So if you had an independent contractor who worked 45 hours a week for 5 years, well, 5 hours a week for 5 years, you now have to go back and pay them overtime for, and also damages, because the Department of Labor doesn't like that. They want you to treat your workers like the workers they should be classified as. So there are key terms in any contract. For employees, an employment agreement might be as simple as a letter that they sign. It might just be an acknowledgement that they agree to the terms of an employee handbook. For independent contractors, all of those terms need to be spelled out every single time, which brings us to the marriage of service providers and IP, which is the classic work for hire agreement. So this is another one of those terms that lawyers love to hate. Work for hire has a very specific meaning under copyright law. It does not mean that everything you do belongs to me. It means, so what you should do is get an agreement with your independent contractors that are developing content or intellectual property or assets of any kind for your video game, an agreement that says that you own all of those things. That's what you would commonly call a work for hire agreement. I'm running lower on time than I would like to, so I won't go into the copyright definition of a work for hire. The assumption for employees, full-time employees or part-time employees who are payroll employees, is that if they're working for you on your project, it belongs to you. Most bigger companies will have an invention assignment agreement anyway to doubly cover that and to make sure that if the law changes, they have a contract to fall back on. Also to make sure that you never say you didn't understand that's how the law worked, although that would not really get you out of it. They can always come back to that agreement and point at it. That says not license. It should say not a license. So what you don't want to do is sign with your independent contractors or your employees a license agreement. What that means is they continue to own it and you have certain rights to use it. If what it says is you have exclusive rights in perpetuity over all uses, that's one thing. But if what it says is you have certain defined rights, that's not very useful to you if you go to make a sequel, or if you go to make a movie, or if you go to make a series of children's books, or whatever, or dolls, or whatever ancillary product you might want to put out. If the license doesn't give you those rights, you'd have to go back to those employees or contractors and get those rights from them. So it's better just to own it all outright. If you own it all outright, you can always give them a license back. So, for example, it's very common for artists to want a license back to include their art in their portfolio, to be able to say, I made this, and to sell their services to other projects. That's okay to do. The one caution I would say there is have something in there that says after the commercial release of the overall product. Because what you don't want to do, and this happened, I think it was THQ this happened to, an artist was going on job interviews showing their portfolio. Their portfolio had unreleased artwork from a game that wasn't announced yet in it. And so then games journalists found out and the game was leaked because they had this license that they were allowed to show their portfolio. So you want to have something in there that says when they can actually share it unless that's not an issue for you. If you've already announced, that may not be an issue for you. So backstop, I think I mentioned having that backup. So the marriage of money, services agreements sometimes, and licenses is a publishing agreement. So publishing agreements are kind of the culmination of everything we've talked about so far. It's where corporations come in and pay for certain rights to your game. So basically, it's the same key provisions of a license, it's the same key provisions of any contract, and it may be the same key provisions of a services agreement if the publisher is agreeing to perform certain services for you. The crucial thing here is read it, read it, read it. Read the publishing agreement. Don't sign a publishing agreement you haven't read. I say that having read lots of publishing agreements and knowing that publishers put terms in because publishers do more than one publishing agreement. And they put terms in that maybe they didn't even intentionally put in. They just borrowed their last publishing agreement, and it doesn't match what you think you've agreed to. So to kind of piggyback back to the other types of agreements. So the licenses, you want to know what you're giving them. What rights do they have to distribute the game or market the game? What rights do they have in ancillary products, in spin-offs, in merchandising deals, in commercial exploitation? So if you make a game, can the publisher license it to Domino's for use on a commercial? That kind of thing. All of that should be spelled out. If it's not, it can be spelled out in broad terms. It could be the publisher gets all rights. You could say, this is essentially a work for hire, quote unquote, that the publisher now literally owns it. It could be far less than that. It could be the publisher gets North American distribution rights and marketing rights to market in North America only. It's important to know that's probably the key thing to know in the first half of that agreement is what rights you're giving away. Obviously, you want to know what money you're getting for that, if any. If you are getting money, is that money something that they recoup off of sales? If they're fronting expenses to develop the game, they're probably going to want to make that back when you start selling the game. Is there a revenue split at the end of the publishing deal? When you do release the game, after they've made back their money, do they get additional money? Is there a certain amount of money they get? Does it taper off over time? What's the revenue split like for other merchandise, if they are allowed to make a film or anything like that? All of that should be in that agreement, as well as termination, like we talked about before, liability shifting provisions, like we talked about before. Literally everything we talked about for every other type of contract is probably going to show up in your publishing agreement, which is why it's the big one here. So I've got this link here. I have written an 8,000 word manual to publishing agreements that is free. You go to that link, you can download it. If you don't want to pay for a lawyer, at the very least, read the bullet point summary of what you should get. If you don't want to pay for it, there's a link after that link, or if you don't want to give me your email address, which is the way you get it for free, there's a link after that link. You can buy it on Amazon, but I've sold 0 copies. I would like to continue to sell 0 copies. You can also feel free to email me, and I'll email it back to you, but that's not going to save you any time or, preserve your anonymity from me. So I am going to save some time for questions here, but they wanted me to include a number 11. So these aren't really numbered, but there are exactly 10 circles here. So number 11 is down here. It's this little sort of hidden thing here. So this is your number 11. No internet connection. Okay, well, okay, so that's a surprise. That's great. So you don't believe it. So number 11 is You Know Nothing, Jon Snow. And the point of including that at the end is basically that number 11 in any presentation should be that the whole point of this, any legal presentation should be that the whole point of this presentation is to give you a very surface level ideas of things to watch out for and things to kind of have in the back of your mind when you're dealing with these issues. The most important thing to know is to know what you don't know. So if you are a very talented programmer and you make a game, it's probably not going to have the best art, right? The same can be true if you're a really talented lawyer and you try to do a tax filing for your client. You're probably not going to do as good a job as a CPA would. So that's not to say you can't learn the law yourself and do it yourself, or learn taxes yourself and prepare it yourself. just know what your limitations are, and when you get to a point where either you're out of time or you are out of knowledge, be prepared to hire someone, not necessarily a lawyer, could be a CPA, could be an artist, could be, whatever field you're not an expert in. Know what you don't know. All right, so I've got, I think, about 10 minutes for questions, which is right on target. All right, we'll start here, we'll move back and then back up.
What would you say, like you have an indie team of friends and have like a handshake agreement, hey, we're going to make this game and split the revenue. What should they do to formalize that? Do they go to an attorney who then drafts up a contract everybody signs, and how much does that typically cost? Like, what would you advise someone?
Yeah, so I would say that for your standard indie team, say 4 to 5 people, and maybe they're just out of school or whatever, I would always say talk to an attorney. If you can't afford that, there are ways you can formalize it without talking to an attorney. Definitely put something on paper. I would say form an LLC. Most commonly form an LLC. Make all of the original contributors members of the LLC and have them all contribute their IP contributions to the LLC so that then the LLC owns it and no individual one of you owns it. You'll have to have some hard conversations about who owns what chunk of that LLC. And also, if you have people that are flight risks, then this is where you get into the lawyerly stuff. It's a good idea to subject their equity interest to vesting. So to say, look, you have 20% now, but if you leave after a year, you give up 15% of that 20% or something like that. That also has some tax filings that you should do called an 83B election. You can Google that. It's one sheet. You mail it to the IRS. But there are things like that if you go to an attorney, they're going to try to include in those provisions to make sure that the LLC is the most protected of any of the individuals involved. If it's just you working on it, I say work on it in your garage as long as you can. Before you release it, form a single member LLC. It's probably about $200 through whatever state you're in. Unless you're in New York or California, then it's significantly more. California is $75, but there are other filings you have to do there. But New York is very expensive. But it's probably about $100 to $200 in your state. Form the single member LLC the day before you put it on the market and sign one piece of paper that says I contribute the entire game to the LLC. What that does is then if there are problems with the release that cause liabilities on the outside that are not, so there are certain types of things that you still can be personally sued for. In fact, there are a lot of them, but it's going to protect from a lot of other types of things. And it's going to protect from like common debts. So if you owe money to someone from the game after you form the LLC, that would be covered. But if you owe money to somebody before you form it, that's still on you. But form an LLC, write something down. If you can't afford an attorney, at least paper napkin it, write something down. So to the back.
Well, before I ask my question, Dancing Baby.
Oh, the dancing, yeah, the lens.
Yes.
Yeah,
Prince.
Yeah, so for those not familiar, this is
It's a housewife too. It's
yeah, so this is Lentz v. Universal Music.
She was able to write Lentz v. Universal.
And it was a Ninth Circuit case. Basically, the whole thing started. This woman posted a video to YouTube that was her video. It was a video of her toddler or maybe even baby, like very small child dancing, and there was a Prince song that the baby was dancing to. Universal Music, to make an example of her, sued her for copyright infringement. And that case went on, I think they sued in 2003 or something, and that case just ended. And there's arguments that it's not even final now. But she was lucky enough that the Electronic Frontier Foundation felt bad for her, and so they stepped in and paid her legal fees. And they represented her through the whole thing. You can't count on that, right?
Well, what if you know somebody in EFF?
Yeah, and well, even if you know somebody in EFF, they only have so many resources, right? And they have to pick and choose their cases. Yeah, but yeah, so the Lentz v. Universal Music. There's also There's new case law out of the Ninth Circuit that says when you do a DMCA takedown, which is where someone sends a notice to YouTube and says, this infringes my copyright, the Ninth Circuit now says that before sending that notice and before YouTube takes it down, they have to give some weight to a fair use consideration. Also, you can't depend on that because that's Ninth Circuit case law. It's probably not case law wherever you live, unless you live in the Ninth Circuit.
But that's not my question. My question
Okay.
is, with regard to capitalization agreements, there must be rule of thumb based on context. For instance, if you're in the gaming industry, there must be some type of general rules on percentages, and so, or is that just the Wild West?
Well, so it's a little bit Wild West. There are industry norms. I will say that in the indie world, those industry norms get skirted all the time. It is not uncommon to see a clever artist who feels that their art is the most important thing get a unsizable amount of equity in the startup, even though the game development is being done by a team of 50 people. It's also not uncommon for a musician to get more than what I would deem their fair share, or for an agency type producer who's going out and finding investors, they may take a disproportionate chunk. So there's not always a good metric to go
Is there
with.
any way to find out what common practice is?
Talk to people.
Yeah.
Talk to people who've done it before.
And lawsuits?
And what?
Elements of lawsuits or something?
Yeah, you might be able to, yeah, that's a good point. So places where that has already been litigated, where people have fought over their equity split, you may be able to find that in court records. But that's not going to tell you whether it's typical. It's just going to tell you what it was in one deal. Yeah, that's, if you're not an attorney, there are free resources for legal research. You can go to Google Scholar and click case law, and then you can try to search for different terms that might turn it up. You can also just search Google regular and see what you find. Gama Sutra, a lot of people have written articles on starting game studios. That's a pretty good resource for what they've done. It might not be industry standard, it might not be the norm, but if you compare enough sources, you can kind of figure out what you think is right. As a general rule, if there's someone who is absolutely critical to your team and is literally irreplaceable, the ball's kind of in their court, right? So, yeah.
I have one question, and I have another question. So let's.
You can ask both.
So first question. So it's common, well, not as common as it used to be because the gold rush is starting. But like a Kickstarter-like project, that you, like, I have a game idea, I have some concept art, I have a little bit of game for I want to raise money to like fiction. Where does that fall with like copyright law and like follow copyright and like what do you do?
So, yeah, so video games and copyright registrations are a little bit tricky because you go through so many phases of development. You're not going to file a registration every time one thing changes, right? That would be insane. A lot of companies don't ever file it. I personally would say that when you release the actual game, file a registration. Copyright registration is cheap. It's like $35. It's not a difficult process. Clients I have that do it repeatedly, I don't do it for them anymore. I sit down with them for 2 hours, show them how to do it, and then I never touch it again. It's not a complicated process to file a copyright. That said, if you're going to file a copyright every time one line of code or one piece of art changes, $35 a million times is pretty expensive, right? So don't do that. That would be silly. But yeah, so that's your copyright question. On the Kickstarter point, I would also say be really careful with crowdfunding. There's the legal reason to be careful, and then there's the practical reason. The legal reason to be, well, many practical reasons. The legal reason to be careful is if you mislead people into purchasing something, you could be liable both under false advertising statutes and just potentially fraud claims. So be very careful there. The practical things to be careful of are A, if you promise something and you don't deliver it, you're going to get bad press, right? The other thing that I think a lot of people don't consider is the costs of running a Kickstarter. So a successful Kickstarter is going to have a time investment to get the audience there, right? You're going to be doing social media. You're going to be, maybe you go to events to just plug the Kickstarter. It's going to be time intensive to get a successful Kickstarter off the ground. The other thing is that if you do a successful Kickstarter, say you targeted $100,000, you raised $100,001, but you promised t-shirts at the $20 level. Now you have to go out and buy, 5,000 t-shirts? That's expensive. So make sure that you factor into each of your reward tiers the actual cost of delivering those rewards, and the shipping costs of delivering those rewards. That's where a lot of my clients end up getting in trouble, is they do this Kickstarter, they've budgeted out their rewards, but they haven't budgeted out that they allowed people to enter into their Kickstarter from Europe, and it costs $25 to ship a pin to Europe. So keep all of those logistics in mind when you're doing a Kickstarter. You can get in a lot of trouble if you say you'll get a t-shirt and then you don't deliver a t-shirt. More questions? Yeah.
You said some contracts have to be in writing, some don't. Do NDAs have to be in writing?
Yes. So, yeah, basically yes. There's no such thing as a friend-DA. Yeah. The short answer is yes. Get an NDA in writing. The writing, for any kind of agreement that's required to be in writing, unless there's what's called a statute of frauds, which requires certain types of writing, an NDA could be an email exchange that says, do you accept these terms of confidentiality? And they reply, yes. You have a written track record then. Don't rely on an oral NDA. That's a terrible idea. Because they're just, honestly, don't rely on an oral contract. This is the lawyer's advice. And this is non-legal advice, right? This is legal information. Don't rely on an oral contract, because an oral contract might be enforceable if you can prove it. But if you're dealing with somebody who doesn't like you and is fighting with you, they're going to lie. All right. Question? Yeah.
To follow up on that, is it okay?
Did you have a question?
Yeah.
Yeah.
I was just curious, you talking about the type of clients you manage and your history.
Sure. So I got into games because I was working at a media firm. So I was working with newspapers and television stations, and number one, I love games, so that's the starting point. But number two is that, pure financial reasons, frankly, I didn't think newspapers were going to pay for me to retire. So I kind of explored and said, where does my skill set work? And that was 5-6 years ago. And then I just sort of started with, a one-man team. I started with one guy who was making one game, and then it grew from there, and now that's really the bulk of what I do is video game work. But basically, I work with studios, again, from one man up to, I think my biggest client now is 49 employees. I have one-off things with bigger companies, but so what I try to do is what I call outside general counsel work. So what that means is I try to be the point of contact for the person running the company or the business of the company. If it's something I can handle, which is most corporate and IP issues so corporate issues, when they hit a certain point, I will either bring in other lawyers or refer you to somebody else. So if you've got a $50 million company and you're going to sell it, I'm not going to do that by myself. That's going to require a lot of man hours and a lot of team members, and I'm going to bring in other people for that. But for, general contract review, licensing agreements, general employment questions, all of that I will typically handle myself. But usually it's for the companies, not the individuals. Yeah. We're out of time? Okay. I'm going to be around. I'm going to try to stick around for the keynote, so if you can catch me between now and the keynote, I'm happy to answer more questions in the hallway. Thanks.